All right, and bailiff, will you please call the case? Well, I think you're muted. Mr. Kaplan, I think you're muted.
Apologies. Good morning, Your Honor. The matter before the court this morning is a case entitled State v. Allen, case number 24 AP 063. Representing the appellant, Rakeem Allen, is attorney Stephen Dunham. Representing the appellee, State of Vermont, is attorney Diane Wheeler.
And Mr. Dunham, you have 10 minutes, and just introduce yourself and introduce your client. I've been doing this job one degree or another for 25 years, and it was many years ago I used to give lawyers a hard time about being late. I've never had someone late for the Supreme Court. I'm not gonna give you a lecture on that. You seem like you've been practiced for a long time and understand the consequences of not appearing on time. So we'll just leave it at that, and you can begin your argument.
Yeah, Steve Dunham for Rakeem Allen, and start off. The link wasn't live. I had to call the court to get it again, so I apologize for that. We've briefed our position, hopefully pretty well. Our position is that the court did not make or justify a finding of a reason for cash as opposed to a percentage deposit or consider an appearance bond. And we also improved our surety for an appearance bond by showing that Mr. Allen was actually good for a $7,500 bond, but the court rejected our offer for a lien on the title for his BMW, which is booked between $8,000 and $10,000. So we were asking the court.
The BFW? I thought it was his father's mobile home.
No, that we realized that that now it was down to 7,500. That he had the BMW, so we filed a note to secure the bond in the event that the bond was forfeited, and we filed the title. We gave the court the original title, and we had $200. We have $200 to pay the title fee, and the court can hang on to the original title when it comes back. The plan was to have the title go back to the court first, the court to have control over it, make sure the transaction is done. When it got back to potentially hold the title until the bond was released.
So where was that in the record on that was posted? All I saw was the arguments regarding the father's mobile home as a potential surety.
There's an entry order from a week ago, Tuesday, I think, or Wednesday, that where the court declined to take the car.
Not take the car, just take the title, correct? And when that car, the court doesn't have any ability to store the car.
Well, we offered to store it in the city police impound area for the court, but if the court doesn't want it, it's in a carport for the winter, so we would also agree to leave it there.
And he has clear title to the BMW.
He has the title endorsed over to him by the previous owner, and it hasn't been processed by DMV, but the original title is with the court.
Okay, but as to ownership of the BMW, is there any question regarding ownership of it?
No. But there's no liens on it, so we would have to get the lien on the title. But I'm not sure where the state stands on this. I think the state thinks that it's sufficient surety, but probably doesn't want to have to store it in the impound area, but we're flexible on that.
But the title is that he has the current title signed over into his name.
Well, yes, the court has it now. I don't have the original.
Okay, so and the trial court rejected the BMW.
Correct. And there was a defect in my note, so I filed a replacement note. That certainly is an odyssey.
Then which note is that, sir?
Well, I used a note like we were securing something else. I took a package for like real estate, and I had to change it to the language to make it secured by the BMW rather than securing a car. I mean, a house.
Okay, so is that where some of the confusions come from?
No, that was after the court's ruling. I cured the only defect I could cure, which was the note.
And has there been any ruling on that on your attempt to cure?
No, there's been no proceeding. It's all been based on filings.
And how did you submit the valuation of the BMW?
I submitted the Kelly Blue Book.
Okay, so so you're relying on cash or adequate surety, utilizing the BMW as adequate surety to ensure his appearance.
With a 750 10%. So
With the
so
what
he's-
now?
750 cash deposit and the remainder secured by the note and the title. And the lien, putting the lien on the title.
So what's the purpose of the $750 if the value of the BMW is $7,500?
We're just trying to do whatever we can, so we're tapped out at around that number for cash. So we're fine with $7,500 note with no, bond with no cash. But
I'm sorry, I mean a signature where he's just signing over, where he's signing over his signing a promise that if he were not to appear, that he would pay $7,500 without any security.
well, that's fine, but we're also fine with the no, we would also do the note. We already filed the note for the 7,500 with a so it would, and the court also has the title application signed over, so it's ready for the holder of the actual title, the original title, to submit it to get the lien on the title.
The lien by the court.
The lien by the court on the title. There's a title. There's a title application signed by Mr. Allen for
Okay.
DMV. So the DMV package is all prepared except for the fee, which the court declined to take the $200, but I have the $200 to cover the any fees of filing for the title.
Okay, and most of what you argued was regard to the requirement that the trial court impose the condition of release, excuse me, the cash as a 10% posting by the defendant, so that if he appears for hearing, that the $750 would come back. Is there any case that you're aware of that is the preferred procedure, or that's the mandatory procedure, 10%?
I believe there's a long line of cases that are in my memo, Your Honor. The most recent of them is my case and Adam Tatro. There's also,
Mr. Kaplan, you have 1 minute left.
okay, I'm sorry. In my haste to try to get through this WebEx thing, well, the cases are in my memo. There's Tatro, and that's attached to my brief. There's starts with Bailey. I think that's a full court case, and then it goes on to.
Correct me if I'm wrong, Mr. Dunham, but it's my understanding that it's an option, but it's not a requirement.
It's a requirement to go through the progression, looking at the least restrictive. So either the court doesn't give a good reason to, or make findings that unsecured appearance bond or a 10% appearance bond are not sufficient. So I think my time is up, so I'll at least pause.
All right, thank you. Ms. Wheeler?
Good morning.
Identify yourself and identify your client, please.
Yes, Your Honor. I'm Diane Wheeler. I'm a Deputy State's Attorney in Franklin County, Vermont, and I represent the state of Vermont. In this particular matter, the state does not oppose Mr. Dunham if the court is going to accept the note on the BMW and the $750 cash. The state does not oppose that. It was the state's position that secured the $7,500 cash or surety that the court had required.
And that's consistent with Hance, is it not? That's what the state of Vermont versus Henry Hance stands for, is that you can use property instead of cash.
That's correct. Yes, Your Honor. So that's why we did not oppose that piece. That's a recent development as of the last week. The only thing the state opposes is leaving the car in the St. Albans City Police Department lot because of their liability issue. So that is where this stands from the state's perspective, that Mr. Dunham's proffer and offer of the BMW plus the cash satisfies the requirement of $7,500 surety.
But did the trial court reject that? Again, this is something I'm not aware of. It's not part of what was presented as part of this appeal.
He objected Mr. Dunham's original filing because there were a couple of defects in it. As Mr. Dunham indicated, he corrected that as best he could with the title. So again, the state has had prior experiences where people have given the court the note for their home or something of that nature, and that has worked. So again, the state does not oppose Mr. Dunham's way to come up with the monies necessary or the sureties to have his client released.
Any question regarding the title ownership of the BMW based on the title that was presented at the hearing?
No, Your Honor. Mr. Dunham did provide not only copies to me, but he allowed me to view the originals, and it seemed to be in order from what I know about DMV and having transferred some vehicles myself.
And was there any question regarding the value of the BMW?
No, Your Honor, it was the Kelley Blue Book value. I double checked that.
So what would be the state's request under the circumstances here? Has the trial court had the full opportunity to evaluate the use of adequate surety as presented with updated information from Mr. Dunham, or is that something that still needs to be set with the trial court?
I'm sorry, Your Honor. Yes, I believe that still needs to be set by the trial court. I have not seen an opinion on the amendment that Mr. Dunham made.
All right, so that's still somewhat pending in the trial court.
Yes, Your Honor.
Okay,
Mr. Dunham may have more on that, and I'm happy to give my time to him.
well, thank you, Ms. Will.
Yeah, it sounds like we have an agreement. The only question is how to execute it. Did the court actually challenge the authority to take a car as and take a car as surety?
I think that law has been settled for many years in the state of Vermont. As long as there's, it doesn't necessarily mean what it is. It's a matter of a question whether that's adequate surety. And jewelry can be adequate surety, homes can be adequate surety. It's how you make sure that those things are put in a protected state so that homes can't be transferred or can't be, all the equity in the house can't be withdrawn based on a home equity loan or whatever else, or that this BMW can't be sold as while it's being held as surety by the state. But if the title is being held, I mean, that's something unto itself. But I think that's something better off being determined by the trial court than by this court.
Yeah, the court already determined that but an entry order without a hearing, Your Honor. So right now we need to set that aside at minimum or do a stipulation. Where does the state want the cars? You're fine if we just leave it in the carport?
Mr. Dunham, you and I can work that out. But
Thank you, Ms. Wheeler. I don't want to get in the middle of these discussions. It's really not for me. But well, I'll take this under advisement. I'll issue a written decision. And maybe the parties will submit something to the trial court. And I'm not sure what the schedule is for the trial court, but I would say maybe if you could get something to the trial court within the next 3 business days, and then we'll hold off on issuing a decision depending on that. Does that work?
We have a hearing on Monday.
Okay.
Although I'd like to do it today, but anyway, so Your Honor, I think the appeal volume doesn't include the filing since the file was shipped. So
it does not.
Yeah,
that's what I've seen. So, well, I'll sort it out on our end. It sounds like you have a hearing on Monday with the trial court. You can bring this up at the trial court at that time, and what the circumstances are. The title is already there. It's going to be a question of logistics regarding the location of the BMW. I'm sure you can work out that as well, and then we'll do what we hear. But the decision I have is the only issue is regarding the court's determination of the $7,500 cash without using 10% or a personal guarantee. So we'll sort it out, and then we'll go from there. Anything else, Ms. Wheeler, on your end?
No, thank you, Your Honor.
I appreciate both your accommodation regarding the doing this by audio only, and then we'll sort things out.
Great. Thank you, everyone. Good afternoon, morning.
Good morning. Thank you.